Our court system must function efficiently and effectively because Canadians rely on it every single day. Court must have the resources to function effectively. From staffing to infrastructure, our courts need resources to ensure that justice continues to be served. Governments at all levels must understand that funding for justice initiatives is required to sustain our democracy.
Supreme Court Chief Justice Richard Wagner giving his annual address to the media today. It's a rare look at the thinking behind decisions made by this country's highest court, with issues of judicial vacancies and the role of artificial intelligence in the legal system top of mind for the justice, who is here live with us now in studio. Hi, Chief Justice Wagner. Good to have you here. I appreciate you making the time. Just over a year ago, you wrote a very specific letter to the Prime Minister about the delays in justice, essentially, writing that the government's inertia regarding vacancies, judicial vacancies in reference to that, and the absence of satisfactory explanations for these delays are disconcerting. For lack of a better term, do you think you lit a fire under the government?
Well, I think that I wanted to raise a red flag, and I think it worked because the situation has improved. So last year, in the month of May of 2023, as you know, I sent a private letter to the Prime Minister, although it was leaked eventually, following a meeting with my 44 Chief Justices and Associate Chief Justices at the CJC. And they complained about the fact that there were some vacancy, that judges were not appointed within a reasonable delay, and that created problems. And so the next step was to alert the Prime Minister and Privy Council, and that's what I did. And as you know, I was mentioning in my letter that appointing judges within a reasonable delay was part of the solution, not the only solution to shorten the problems and to limit the problems at the courts. But it was one easy solution to do. And that if we would not do that, there was a chance that there would be stay of proceedings in criminal matters because judges were not available to hear the cases. And we know that that's what happened during the last year. But apparently, the situation has changed. And as of June 1st of this year, there were 57 open positions, whereas last year it was, I think, 90, 94, something like that. So there's an improvement. I think that government has recognized the seriousness of the problem, and I am confident that they will continue to make the appropriate decisions.
You mentioned that it's not just about filling judicial vacancies contributing to delays. Has the government sought your advice on other aspects of the problem they could address?
Well, there was an increase in legal aid, which I understand the new Minister of Justice has announced recently, which is part also of the solution. But administration of justice is also a provincial jurisdiction. So all the stakeholders in the area has its role to play. And provincial governments must make sure that the courts have the proper funding, that they have enough technology, and that the judges could do their work properly. And the federal government has the duty to appoint judges within a reasonable delay. So, and the judges as well must make sure that they undertake proceedings to facilitate access to justice and to make sure that people know about their rights.
Let me just parse that apart for a second, because I think just to ground this for our audience, what they have been reading are headlines about pretty significant criminal charges in a variety of provinces across the country being stayed because of a ruling, the Jordan ruling, basically, right? Which sets a time limit for how long really a case can unfold in the courts in order for there not to be a miscarriage of justice. Essentially, I think what they're asking is, why have there been an increase in many of the provinces of these cases? I'll point to two examples. In Ontario, 177 charges stayed last year, 96 cases in Quebec. In both of those provinces, it was a jump over 2022. Is that the province's culpability? Is it the judge problem? Is it a mix of that? Like, what is your message to Canadians who are listening tonight, worried that they're a victim of a crime that will never be prosecuted?
Yeah, well, let's make one thing very clear. One stay of charges is one too many. There should not be any stay of charges in Canada. But there are many reasons why there could be a stay of proceedings. Jordan is the consequence of the lack of investment by governments for many, many years. So the court had to resolve this issue of determining when an accused has the right of a trial within a reasonable delay. That's the Charter of Rights. And the court decided in 2016 that it was 30 months. So governments, people need to accommodate Jordan, not the other way around. Because I think that in our society, every person accused of a serious crime or lesser crime has the right to have a trial within a reasonable delay. It's unfair for the accused not to know his fate or her fate. It's unfair for the victims that would need to testify within the following years. It's unfair for society as a whole. So I think that the society, the government should accommodate Jordan and not the other way around.
How big is the gap? Pardon the interruption, but how big is the gap? How much more does that require when you talk about funding, for example? I'm not saying put a number on it, but is it in this area of fiscal restraint, like a big jump that they would have to make in order to adequately fund the system so that they can comply with Jordan?
Well, the legal system in Canada was always, and it's not the first time that I say that, was always the parent pauvre of governments and society. It's the same in every democratic society, where governments for years and years invested in health and education, which is great. But the justice system was left on the side for so many years, for 50 years at least in Canada. So not enough judges, not enough courthouses, not enough money in technology. All those reasons created the delays that we lived through in 2016, which caused Jordan to be released in order to limit the time where somebody would have his trial in the criminal matter. So those are the reasons why governments need to invest more and to understand that the justice is not just a service, it's a human need. People need justice. And if they don't have justice, there will be chaos. So we need to facilitate access to justice. That means additional investments. But that means also to be more creative for lawyers, for association of lawyers, for pro bono work, for instance, to find new ways to help the justice system to release justice.
I just have about a minute left, but please do correct me if I'm wrong, but if I interpret your comments, there's a party, the bloc in the House, that essentially wants to introduce a new law that would apply the notwithstanding clause to Jordan, and basically say that you can't apply Jordan's ruling to serious criminal matters. If I interpret your comments correctly, that really isn't a sustainable long-term solution.
Well, I don't want to get involved in a political debate, and that's.
But that would not be accommodating Jordan. It would be trying to make.
Insofar as the courts are concerned, and I'm only concerned with the courts. I'm not a politician, and I will not get into the political debate. As far as we were concerned, Jordan was released because we had to interpret the Charter of Rights. And the Charter of Rights said that any accused has the right to a trial within a reasonable delay. And the court said it's 30 months. So that's the law. Now, Parliament is sovereign. Elected officials can legislate as they want. That's up to them to decide. But as far as the court is concerned, the debate is closed with Jordan.
Okay, I'll leave it on that note. Chief Justice Wagner, pleasure to have you here in studio. I appreciate you making the time.
Nice being here. Thank you very much.
Thank you so much.